sensitive. Okay.
Oh, okay.
All right. You think after having gone through federal prison and everything that follows, I'd have a thicker skin, but I don't. Hey, that's Ron. I spoke with him earlier today. Good to see him. Okay. So, all right, Scott, you're going to continue to let everyone in, correct?
Correct.
So let's get going, everyone. Thank you for joining the webinar. We are recording. As a reminder, if you have questions, hit the raise your button hand. If you have questions, add them to chat. If we don't answer everyone today, we will, either by bringing Jon back or we'll respond to them in a separate video, but we're going to address as much as we can today. With that said, Jon, thank you for returning for your fourth webinar. By now, everyone knows your background and resume. Let's jump right into the ending of the CARES Act. Some people freak out and presume there are no early options or earlier release from prison with COVID ending, which of course isn't true. So can you summarize, with COVID and the CARES Act ending, what options for an earlier release from prison still exist? Let's provide some good news to start.
Yeah, thanks, Justin. And again, I appreciate you having me back. So all of the existing or the pre-existing authorities for early release are still in place. And we'll talk about one additional under the First Step Act that came in place. So you still have the ability to get early release for participation in the residential drug abuse program. You still have the ability to get early release under the elderly offender program if you're 60 or older and have served 2/3 of your sentence. The most significant is maximizing the good conduct time credits and also maximizing the earned time credits now for program participation under the First Step Act. Again, compassionate release. And then probably the best news that the First Step Act brought about is it made retroactive the Fair Sentencing Act of 2010. So you have the ability, if you're convicted under the disparity between the crack cocaine and the heroin offenses, to petition the court for a reduction in sentence in accordance with the Fair Sentencing Act. And I think that's the list of them for now.
Excellent. People mistakenly read something and think it's true, or they misinterpret what they've read. Compassionate release was enhanced by way of the First Step Act, and people presume when they hear that COVID's ending, that compassionate release does not exist. Can you confirm that is the compassionate release is still very much alive and alive? I think we muted Jon by mistake. Jon was muted. Jon, hold on one second.
Okay, I should be unmuted.
We're back. Yes. Talk about compassionate release still exists.
Yeah, so compassionate release was not part of the CARES Act and is not governed under the CARES Act. Compassionate release has its own authorities and was also granted additional authorities under the First Step Act. So compassionate release is absolutely very alive and well.
Let's talk about managing expectations. There are people, including many on our webinar, who may surrender to prison for 1 to 5 to 10 years. Someone on this webinar, I think, is going in for 13 years. And they may have some health issues and feel as if they qualify, and they may, but there's this expectation immediately upon their surrender to federal prison, they want to apply for a compassionate release. I presume they're allowed, but it might not make the most sense. Can you talk about kind of managing expectations, getting going in your sentence, perhaps building a record if there are health issues, why you might be worthy of a compassionate release? I think it's essential that we manage expectations for people traversing this system.
Yeah, so compassionate release allows for individuals with underlying health conditions, normally terminal conditions, or having family members with health conditions, again, normally terminal condition, to apply for compassionate release. However, there's still the eligibility requirements under the compassionate release. And one of those is that you have to have extraordinary compelling reasons. There's a time frame that you have to have served so much of your sentence. So all of those different things have to be met. Ordinarily, I would tell you that you're not going to get compassionate release immediately upon entering the Bureau of Prisons. There's program statement and there's 18 U.S.C. codes that cover it. And, make sure you meet the requirements before you apply for compassionate release, or at least getting close to that.
And with that compassionate release process, does that begin with filing an administrative remedy in prison, or should someone go directly to the court?
So the First Step Act actually allows you to do it both ways. And interesting enough, you can petition the court directly now. I would still tell you the best approach has always been to petition the Bureau of Prisons. And hopefully when you do that, the Bureau of Prisons will then petition the court on your behalf.
Excellent. Thank you. With COVID, people were going straight to home confinement. With COVID Emergency Act ending, are there still mechanisms to go straight from prison to the halfway house, prison to home confinement, or will there be some time in the halfway house before transitioning to home confinement, generally speaking?
Yeah. So CARES Act specifically extended the Bureaus of Prisons authority to place people on home confinement. So during the CARES Act, during COVID, you saw a whole bunch of people going directly to home confinement. That practice was allowable prior to the CARES Act, and is still allowable. So if you have an appropriate release plan, if your release plan shows that you have an appropriate release residence, and that there is no benefit to be gained from putting you in a halfway house, you can go directly onto home confinement.
So, John, something we mention every week, we can't change the past, can't guarantee the future, and we encourage people on this webinar to use their own critical thinking skills to make decisions they think that are best with all of the volumes of information that are out there online. To that end, there are people who spew, or I shouldn't say, to them it may be true, to us we think it's absurd and insane and tragic, but there are people in this justice-impacted community who convey that a release plan is garbage. It's of no value. Your case manager is going to throw it in the toilet, throw you out of the office, and it's a waste of your time to create it. We, of course, have different messages from you and wardens and judges. We want you to use, all of you use your own judgment. Can you touch on, in your opinion, as someone who worked for the BOP for more than 20 years, the value of a release plan and why someone should create it?
Yeah, I have said over and over again, and will continue to tell you, that a release plan is very valuable. It shows your case manager, it shows the staff that are involved in your release planning that you have put forethought and planning into what you're going to do once you release. And it really shows them the progress that you've made towards that release plan. So again, a release plan should be a very fluid and dynamic document. You should be updating it every time you go through a program, every time you do something within the prison system, you attend a class, any of that. And that release plan is really intended to document that journey to where your case managers, your unit team, the RRM, your probation officer can then make really informed decisions about your level of supervision when you get out and your level of freedom. And, that alone is critical. Now, you may have staff, Bureau of Prison staff, I always say varying degrees of professionalism amongst any staff member, no matter who you work for. You may have staff that say, hey, I don't need that. I don't want that. It's always incumbent upon you to make sure that, hey, can you put a copy of that in my release packet? If they say, no, I'm not going to do it, fine. Then send a copy out to your probation officer, send a copy out to the RRM. The more people that you can inform of the good that you've done and the planning that you put into your release, the better off you're going to be. Carry that release plan with you to the halfway house. Carry it with you when you go out on home confinement. Inform people of what's going on with your plan and how you're going to be successful.
Earlier this morning, Ron's getting ready to surrender to Montgomery for 6 years. We had this conversation about some people in prison, they can influence other people. And I share this story, John, when I met Michael in prison and I began to write, people said, don't write, no one cares. People said, Michael's crazy. The guy smiles, he's been in jail for 22 years. There's something wrong with him. How is he so productive and happy at the same time? And a lot of people in prison gain traction and then they can get derailed or pivot because they can be influenced by other people. So I just want you, if you can address the value of using your own judgment, doing your own thing, making your own decisions for people who are getting ready to surrender or who have loved ones in federal prison.
Yeah, I talked a lot when I was working with the population and especially when I started transitioning and doing the reentry programs. And I always told people, do your own time. You're always going to have people that want to be detractors, and some of that may be positive, but a great deal of that is going to be negative. And you have to be very, very careful about people trying to do your time for you and wanting to bring you down, to their level. So be very careful who you associate with. Be very careful who you take advice from. I mean, the same thing applies to all the different advocacies out there. There are people out there that will advocate for you very, very heavily as long as you continue to pay them for those advocacy fees. Whether or not
Well,
their positive impact on that advocacy is different. And understand the journey. Understand why people are giving you the advice they're giving, and then make a decision whether or not you want to use that advice and whether or not it's beneficial to you individually.
when I was alongside Michael in prison and he was writing prolifically every single day, creating these volumes of content, I was initially cynical and asked him, why do you do this work knowing that it might not have this influence? What if nobody reads it? And he used to say, I know my prison term is ending and I know I don't want to be on supervision forever. I know I want to work for myself as an entrepreneur. So since the end is coming, I'm going to do this work and create it. Then he said, I may do work today that may not influence my counselor, but perhaps it influences someone I have never met. So you touched on sharing it with the probation officer and other people. If by chance the counselor says, I have no interest in this, there is a chance that it can influence other case managers or other stakeholders down the road. I share that to inspire those of you or remind you, if God forbid you get that bad notice, we don't want this, that doesn't mean it might not help others in the future. Who are some other people the release plan could influence?
Yeah, so again, United States Probation, the RRM, the actual case manager at the RRC, the facility director at the RRC, potential employers, people that when you're trying to fill that void in your resume, because I was incarcerated for 5 years, 6 years, and you're attempting to fill that void, you can show them that here, I've documented all the positivity that I did while I was incarcerated. And here's the journey I had. All you got to do is give me a choice, or a chance. And I tell everybody the release plan is as much for you as it is for anybody else to see. Having that thought and that personal wherewithal or that personal, understanding of what your journey is and where you're going and what your personal goals are and how you're working towards those and documenting those is going to help your personal self-worth as much as it's going to help you in your journey with others. So I think it's critical that you do reentry plans.
I'll tell all of you on a personal note, as much as my release plan influenced my probation officer, because the day I started probation, my very kind probation officer, Isaiah Murrow, allowed me to work with felons, allowed me to work with Michael upon his, didn't let me visit him in prison, but I didn't want to get greedy. That was okay. But that everyone in prison said, you will never be able to work with felons. You will be on probation. You won't be able to try, it will never happen. And I said, maybe, but I'm going to do it anyway. And it allowed me to have that liberty. And I will also tell you, coming home at 34 without, I wasn't married, I didn't have children. The release plan I created helped when I just transitioned to dating and being able to articulate to someone what I had been through. And I hope it influenced my wife. And we now have 2 young children. So you don't know who it will influence. I just encourage you to do it. John, 3 weeks ago, I opened up a webinar. You weren't on the webinar, but I shared a message from someone that said, I don't know what's wrong with you and Jon Gustin, but I have a complaint. I said, well, what's the complaint? I don't know you. We don't work with you. And she said, Jon Gustin said that you can work for yourself as an entrepreneur in the halfway house. My husband got 9 months. They didn't approve his job. My husband now wants to go back to the minimum security camp. And of course, my response was, Jon said it's a possibility based on the record you've built. So now this spouse is very angry that her husband would rather be back in federal prison than working, I think it was at a coffee shop or donut shop the halfway house had lined up, because they have a lot of agreements with local employers to get back to work. Can you touch on, is it possible to work for yourself in the halfway house? And if so, what are some steps someone should put in place for someone in the halfway house to approve it?
Yeah, Justin, I appreciate that. It's not the first time I've been cussed out.
yeah.
So, I tell everybody, again, I don't speak for the Bureau of Prisons anymore. I'm retired. But I will tell you that policy allows for you to be self-employed as long as that employment was not part of your criminal offense or did not contribute to your criminal offense. So if you're going to go work for, you're going to have your own carpet cleaning business and you've got a plan to do that. and you've got a way to track your income and all of those other things that go along with that, you can apply to the Bureau of Prisons to be able to work for yourself. The attitude towards self-employment or entrepreneurship has really changed recently, probably the last 2 to 5 years. And I'm seeing it more and more within the halfway houses where they're allowing for self-employment, but be persistent. A lot of people, you're going to the halfway house staff and you're saying, hey, I set up, I've designed, I'm going to go work for myself, I'm doing carpet cleaning, and let's just use that. And the halfway house says, nope, can't work, can't do that. Well, I'd like to submit a plan to the Bureau of Prisons to see if we can get approval. Are you okay with that? And be very persistent in that, because it's easy for some people to say no. And let them know policy allows for self-employment as long as certain specific conditions are met. And this is not something I did previously. It's not something that contributed to my criminal offense. So this is what I would really like to do, and I put a lot of effort into it. And then you can do it. Policy absolutely allows for your self-employment as long as it's not part of your criminal offense.
And like anything else, the evidence and documentation is, it was essential for me. Years ago, I attended a sentencing summit where a judge spoke, and she was very honest. She said, I am somewhat dismissive. I don't always believe what defendants tell me. I kind of feel like they are telling me what I want to hear. And if I don't give them the outcome they want, they're not going to follow through and do it. So for everyone listening, would it make sense? No guarantee that it will happen, but doesn't it buoy their chances of getting approved to work if they have documented the business plan, the income opportunities, and whatnot, which then comes back to what people should be doing every single day in federal prison?
Yeah, absolutely. I mean, I said when I retired that, I was going to retire and go work for myself and make $1 million first year. But unless you have a plan and you have things in place to do that, it's going to be very difficult. And we tell the halfway house staff, we tell the individuals that, hey, look, you get somebody that comes out that was a lawyer previously, they're going to have to be very realistic about their ability to re-enter into that law field. And it's your job as a counselor or a case manager in the halfway house to really guide people. So if you have that well thought out plan that's documented about how you're going to do this and what that business plan is, it's definitely going to help you in that endeavor.
So let's talk for a moment about transitioning to the halfway house. There are people, of course, there are disciplinary infractions in federal prison. People think, oh, I'm being released. It's very much a quasi-freedom. Isn't it technically a furlough? And aren't there myriad opportunities to get into trouble and get returned back to prison?
Yeah. So the initial transfer to the halfway house is where you get a large portion of failures for halfway houses. It is a furlough transfer. You are not releasing from the custody of the Bureau of Prisons when you transfer to a halfway house. So it's incumbent upon you to be very upfront and have a really good conversation with your case manager. Number one, how you're going to get from that prison to the halfway house, what your transportation arrangements are, how, who's going to take you, all of that, and then don't deviate from that plan. Any deviation from that furlough can result in escape and escape charges. So not only disciplinary for escape, but could possibly be escape charges depending on how far you deviate. So that's the first thing I tell everybody is really make sure that when you get that furlough paperwork, that you're good with the plan, and that's how you're going to transfer from point A to point B, and then follow the plan.
I also want to address there can be different jobs that get approved. For example, when I came home from prison, I still had a real estate license that was active. My probation officer said, you can't sell real estate while you're finishing your time in the halfway house. But once you're on probation, you still have an active license. It took about 2 years for the Department of Real Estate to revoke it because of my conviction in the securities industry. But there are jobs that you can do on probation, yet you cannot do in the halfway. I want to provide hope to many of you who may have 3 or 6 months and you can't do what you want. Doesn't mean you won't be able to do it on probation. Is that accurate, John?
Yeah, absolutely. And realize that ordinarily for employment, the Bureau of Prisons will consult with your probation officer and say, is this something that you're going to allow them to do on probation? And if it is, they try to accommodate that while you're in the halfway house. However, sometimes they just can't. So generally, yes, if the probation is going to allow it, the Bureau will allow it with some very minor exceptions.
So as a practical example, recently someone in our community, and John helped confirm this, he worked in the wine industry. And while working in the wine tasting industry, he can't do that in the halfway house, but on probation, he could. Could you articulate why, John, he couldn't work in the wine industry while on the halfway house, but he could while on probation?
Yeah, we have pretty strict rules around working in a place that serves or sells alcohol, just due to the culture and the climate associated with that. And I'd actually be very, very surprised if probation would allow him to work in an industry that's going to allow, again, drinking is legal. So if probation said that, yeah, alcoholism, or there wasn't an abuse of alcohol while he was in that employment, so we're going to allow them to do it, they can. The Bureau of Prisons will not. You cannot consume alcohol or drugs, to include marijuana, while you're still in custody of the Bureau of Prisons.
So these are things that all of you need to consider. There are random drug tests. Myriad times when I was in the halfway house or on a weekend pass, I would receive a call from the halfway house that said, we'd like you to return in an hour. Don't complain. You're still confined. You return, you take the drug test, you pass, you get back to it. At times they want to see how you respond. Are you going to complain? Some people actually fail that test. There's this presumption that because you're in the community in your own clothes with your iPhone back in your hand, that you're free. You are not. And if anything, in the halfway house, there can be more supervision. You can even argue pettiness, because they're going to pay attention to more infractions than they might in a higher security prison, where they're worried about things that are more serious and severe. John, would you concur on those points?
Oh, absolutely.
Okay. John, when I was in the halfway house a very long time ago, I had to pay 25% of my gross pay every Friday to the halfway house. I believe that went away with COVID, with the Emergency Act ending. Do you think the BOP will get, do you think the halfway houses will get back to taking 25% of gross pay?
I sure as hell hope not. So back in 2016, we abolished the subsistence payment for those on home confinement.
Yeah.
So when COVID hit back in March of 2020, I put out a memorandum abolishing the collection of subsistence until further notice. Knowing that, in addition, the Bureau of Prisons, in their newest statement of work, their newest contracts, so in March of 2022, the statement of work went out, also did away with subsistence and any collection of subsistence in that SOW. I believe it's the intent of the Bureau of Prisons to continue to abolish the collection of subsistence. However, there are still going to be some of those contracts prior to 2020 that were awarded, and there probably needs to be some clarification given to those contracts that it is the intent of the Bureau of Prisons to continue with not collecting subsistence for any reentry program.
John, many people pay FRP, financial responsibility program restitution in prison, as I did. Do you continue to make payments while in the halfway house or on home confinement?
So generally, no. However, depending on your income, yes, it may be ordered.
Got it. Okay, we're going to continue to rifle through some questions with John. We have him till 11 o'clock Pacific. I do see questions coming in on the right. We're going to address them. For now, let me continue to go through our list. For those, John, who are wondering, who approves time in the halfway house? So you're in prison, you're creating this release plan, you're avoiding problems, you're adjusting well. Who's in a position to determine if you get 3 months or 6 months or 9 months in the halfway house?
Yeah, so generally, your case manager is going to make the initial recommendation and provide a range of time for an individual to get in the halfway house. So generally, I want them to get 6 months in the halfway house. I want them to get 6 to 8 months in the halfway house, based on the 5-factor review contained in the Second Chance Act and in the First Step Act. So it then goes from the case manager through the unit team, the unit manager, the case management coordinator. The warden will ultimately sign off on that packet. It then goes out to the residential reentry management office. The residential reentry management office will send that packet to the halfway house. The halfway house will make a determination whether or not you're appropriate for their facility, and do they have the resources, meaning the beds and all that available on that date and time? If so, they'll agree to it. It then goes back to the RRM, who has the final determination of how much time you get in that facility.
In an interview you did with Michael, you had mentioned, I think there were 7,000 halfway house beds in the country or something like that. And with so many people wanting to go to the halfway house and so few beds, it can be very competitive. And I know people tend to be, a case manager is probably going to want to make a good bet on someone going to the halfway house. Would you argue, disclose not just the release plan, but really confirming or connecting with your case manager in a way that says why you're worthy of it is essential? Because everyone wants the most amount of time in the halfway house. Not everyone gets it with so little space.
Yeah, and so you have a couple different things that are now impacting. So I saw somebody throw up a comment that First Step Act credits now impact your time in the halfway house. First Step Act credits, earned time credits, may impact the time that you have in the halfway house. So there's several different factors now that are going into recommendations of time. So remembering that the Bureau of Prisons rules language allows for the first 12 months, up to 12 months of earned time credits to be applied towards early release. So let's say you got 9 months of earned time credits. So effectively that 9 months will be taken off of your sentence and you'll get early release 9 months earlier. Under the Second Chance Act and reauthorized under the First Step Act, they have to do an additional review under the 5-factor review, which takes into 5 specific factors to determine how much more time you should get in the halfway house or make a recommendation for time in the halfway house. So that you get those time credits, then you can get additional time based on that 5-factor review. So anytime, so 5-factor review I did, and I said, okay, under the 5-factor review, I recommend you get 3 months in a halfway house and you have 18 months of earned time credits. Conceivably, by the policy and the rules language, you should then get 9 months in the halfway house or on home confinement, either or.
Okay. So those are helpful. We want everyone to understand that. And we're going to jump around a little bit. We're going to come back to the First Step Act in a moment. In an interview Michael did with Chris Maloney, your colleague from federal probation, Chris discussed the importance of the probation interview. And there are so many people on this call, Jon, see 83 people right now, and I would ask the lion's share of them, were you prepared for the probation interview? And many of them would say no. Many are told it's a 10 or 15-minute interview. Many are encouraged not to speak openly about mental health issues or substance abuse or alcohol for fear it will make the judge kind of punish them for that rather than speaking openly. And so many people just come to regret their preparations. Chris Maloney in the interview with Michael said, one thing a probation officer will probably do once you start probation is go all the way back to the beginning and look at that probation report. And that freaks a lot of people out because what does the probation report convey? The worst decisions we've ever made that led to this criminal offense. So I guess do you not just concur with Chris, but I'd like you to reaffirm if someone's not pleased with the probation report or the narrative, I want to provide hope to everyone that there is time to change the narrative, to create it and document it and share it. If not, you're just going to be judged by this PSR that many of you loathe and hate. Jon, I'd welcome your feedback on that.
So I too loathe and hate the PSR for a number of different reasons. And let's talk about why I loathe and hate the PSR. So the PSR is the document that the Bureau of Prisons gets from the court that tells the Bureau of Prisons the type of individual that you are. And that's the only document that the Bureau of Prisons has to go off of before they actually see you and start doing case management meetings and everything else. So they get a PSR that says you're this horrible individual who committed this heinous crime, regardless of what the crime was. Here's your criminal history. Here's your upbringing. Here's your family history. Here's the problems with all of this. And that's what the Bureau of Prisons has to make initial custody classification and scores based off of. So you go through your entire prison sentence with that PSR, and hopefully you're changing that and your scores are going down as you're doing program participation. But then you're now doing a referral out to the community, out to the RRM. The RRM then gets that PSR and reads about what a horrible person you were at the beginning of your incarceration. And that's the most in-depth document that they have. So they're reading, oh my God, they committed all these heinous crimes and all that. They're asking for a year and a halfway house. There's no way I'm going to give this guy. There's no way he's going to succeed in the halfway house. And they get a one-page summary of all the programs that you've done in the Bureau of Prisons. And they say, yeah, that's great. He sat in a room and he did that. They participated in these programs, but I really don't know if those programs were successful or how they contributed to the programs or anything else, because I don't have any of that documentation. So when you're looking at that PSR, and all that's really to say, supplement it with something. If you're going to supplement that by your really detailed reentry plan, that's what I encourage you to do. Remember, the PSR was designed for one thing, and that's for sentencing. That's what that PSR was designed for. It was designed for the judge to make determinations based on criminal history and personal situation on how to sentence you. It wasn't designed for all the things that it's now being used for. Now, it's a good document to make initial custody classification scoring off of. But at that point, it should really be thrown away. And all the effort and all the focus should be on what good you've done and how you really positively impacted yourself during incarceration. And I just don't think that's occurring. As Chris said, you know, as soon as they get on probation, the probation officer's looking back at the PSR saying, okay, here's what he was incarcerated for. Here's his criminal history. Oh, he's intensive supervision. Well, but are you looking at everything else? Because you're not provided good quality detail on anything else like you're provided in that PSR.
So that also speaks to those who haven't sat for the probation report, or even those who have done it and who still have a chance to influence it, to the extent they can influence the PSR, whether it's with a personal narrative that doesn't excuse but explains their life and who they are, to the extent that they can advocate and try to change the narrative and get that into the probation report, it could possibly influence a judge or people down the road who are going to review it.
Yeah. So interesting enough, so I get a lot of questions is, oh, I've been sentenced. I'm supposed to voluntarily surrender to the Bureau of Prisons tomorrow, but I want to go back in and revise my pre-sentence report. It's not going to do a lot of good at that point in time. You know, just as frankly as I can be, you've already been sentenced. Again, that's what that was designed to do. Now, if your lawyer or your attorney is going to go back and petition for a change in sentencing based on inaccuracies of the PSR, that's one thing. Then yes, absolutely petition to get that PSR changed. But if you're already surrendering to the Bureau of Prisons, you don't believe your sentence is going to be changed or affected by the inaccuracies or additions that you want to the PSR, go in, when you're doing your team, when you're doing your programs, that's when you need to start getting your narrative into the hands of the Bureau of Prisons, and you do that through your release plan.
Got it. So many of you should know, we've had people in our community, even before they've pled guilty, they're creating their plan prior to their sentencing hearing. John from Nebraska 2 weeks ago shared his story of getting his release plan to the probation officer during the probation interview. That in the narrative is actually into his pre-sentence report, which, you know, of course, can have, you know, just benefits for years to come. I'm going to transition to questions in a few minutes. I want to knock out some questions that we continue to receive. Judges can recommend a prison, can recommend a program, but the designation is ultimately up to the Bureau of Prisons, correct?
Correct.
Why would the BOP, for example, potentially send someone who lives 2 hours from a prison, potentially 9 or 10 hours away? What are some reasons that could happen?
Yeah. So the number one reason is security classification. Their security level is not appropriate for the prison that's closer to their home. The First Step Act very clearly says that the Bureau of Prisons must designate to the closest facility to your home, as long as security classification, resources, and other things are appropriate. The other thing that normally happens, and it just happened with the case that I was talking to Justin about yesterday, is population pressures. One camp might be full. You have a rather lengthy sentence or a lengthy enough sentence that they're going to put you at another camp further away. And then as you get closer to your release date, they'll move you back in. So, understanding that this is changing and it's changing dramatically, the Designation Sentence Computation Center is really looking at closest prison now to release residents. And they're doing a pretty good job of it. But again, that prison has to be appropriate for your security custody level, and it has to be, you have to look at population levels and all the other resources, et cetera, et cetera.
So for some of you, for all of you, if you've been, you should know redesignations are possible. And John, I know there's some changes taking place in the drug program and just programs in general. For example, they're closing the drug program in Miami. We have a number of people in our community who are going to be going to Pensacola. Do you expect more changes? And also, when people go from prison to prison, is it the chain gang transit, or could it be a bus? Could a family member pick them up? All of the above? What are some things you've seen if people are transferring prisons?
Yeah, so recently we've all seen some changes to programs that are being offered at different facilities. And it really appears to be based on resources. Like every other industry out there, the prison industry is having a really hard time right now filling vacant positions. The Bureau of Prisons has just numerous positions that are sitting vacant. So you may be seeing some programs that are either temporary shutting down or being relocated based on availability of resources. So we are seeing some of that. I know Montgomery Camp was a good example where it appears the RDAP program has been halted temporarily. But it's my belief, and from what I'm hearing within the Bureau of Prisons, they're looking to expand programming as much as possible, not reduce programming. And that's consistent with the First Step Act. As far as transferring from one facility to another, all the above. You could go on a prison bus, you could go on a marshal's transport, you could go family member furlough transfer. There's all kinds of different ways we do that. So yeah, it's, any plethora of ways you can be transferred.
Let's talk for a moment about First Step Act programming. There are people like Ron, who's going to a pretty big federal prison camp, Montgomery. We have Frank in our community who's getting ready to go to Butner, and everything in between, big and small camps. Are you seeing similar type programming amongst all prisons, or are the bigger prisons having more programming? People are wondering, what prison should I ask for? Is it going to have the first step? I want the credits. What do I do? What advice would you give to someone, or what are you hearing about programs in both big and small prisons?
So you bring up two things there, Justin. Probably the elephant in the room is, what programs do I attend to get earned time credits? So the way the Bureau of Prisons has designed the earned time credits is you're going to get them as long as you're involved in productive activities or programming. So generally, you're going to get earned time credits unless you're not doing anything or there's discipline issues. So when you talk about those 10 days for the first 6 months and then 15 days thereafter, you're going to get earned time credits regardless of what prison you're on, as long as you're participating in those programs that have been designed for you or you were told to attend. So the needs assessment said you need anger management, you were told to attend anger management and you attend it, you're going to get those earned time credits. If you, again, regardless of what prison you go to. The other side of it, and separate from earned time credits, is the residential drug abuse program. So residential drug abuse program is separate from earned time credits and gives you additional time off your sentence for participation in RDAP unless you're precluded based on your offense.
Okay, so that's very, very helpful. I want to begin to transition to some questions along the right. Gordon, for example, wrote, so the probation officer wants to know your side of the story. I'll offer my insights and then John's. Like we frequently say, it has to be the right message. If your side of the story is, I got a bad deal, the government screwed me, and I shouldn't have gone to prison, you are in the population where you should turn in no narrative. You should not create a release plan because it's not going to advance your agenda. It's only going to make matters worse. So when I hear your side of the story, that's somewhat concerning to me. If you've pled guilty, then you need to articulate how you're growing through imprisonment, how you're documenting it, because many can say we're saying it without following through. So John, I want you to just comment on this. So the probation officer wants to know your side of the story. How would you respond to that?
Depending on what your side of the story is. again, I agree with you, Justin. If you pled guilty, but your side of the story is, here's all the mitigating circumstances that led up to this. I really am not guilty, but I pled guilty to get a reduced sentence. Then don't waste your time telling them your side of the story. If there's issues that, led up to, or there's positive things you've done since that, since the time you committed the criminal act, then yes, inform them of that and let them know. And Justin mentioned it earlier, people always think about doing their release plan from the time they were arrested. Okay, maybe I need to start thinking about how am I going to do time? What am I going to do when I get out? And I tell everybody, start thinking about your release plan the minute you decide to do a criminal act.
Yeah.
Because you've got to start documenting, the why, who are you involved in, what was going on, how are you going to change that? What positive things are you doing in your life now? How you're remorseful for that act. All of those things that lead up to hopefully reduced sentence, some compassion from the court, because being remorseful for the act and admitting the act is a big deal when you talk about sentencing. But that's when your release plan should start, and providing that release plan up front to everybody that's involved in your process, and start documenting what's going on. What are you doing? How are you going to change? How is doing that criminal act and subsequently being caught for it, how has that affected you personally? How has that affected your family? All of that. So yes, they want to know your side of the story, but be careful that it's the right story.
Before we transition to more questions, and we have 18 minutes left with Jon, I want to touch on the danger of disciplinary infractions and iPhones. So many people on this webinar were exactly like me, who in a million years never thought they would become immersed in this system, yet here we are. And many of the same people say, I'm not going to get into trouble in prison, yet we get these phone calls from a spouse or a son that says, my goodness, my father's in the hole. And it has to deal with these iPhones. Are they as pervasive as we hear? And what do you think? What is the BOP trying to do to ferret out this massive problems of iPhone? I mean, I hear drones are dropping off iPhones over the prison track. How are they combating this? Because I know the consequences are becoming more severe for the inmate.
Yeah, so there's not a corrections agency out there today that is not combating the introduction of cell phones and other contraband into their facilities. Every time you find a way to dissuade contraband, individuals are going to find ways to introduce it, to include bad staff. So yes, the Bureau of Prisons and other corrections agencies are looking at counter drone technology, blocking signals from cell phones, all of this other technology. But yes, if you want to find contraband in prison, or you want accessibility to contraband, cell phone, drugs, or anything else in prison, you're probably going to be able to find it. If you make that decision to find that contraband and use that contraband and are subsequently discovered, it will greatly impact your ability to earn time credits, good conduct time, or early release. You most likely will not get any of the above. So, again, do your own time. You're going to be introduced to different contraband. What you choose to do with it is up to you.
The best advice that I received after I went to prison, you surrender, and there are people that may look like you, act like you, but you've been there for 15 minutes and you don't know if they cause trouble, they engage in the hustle, they don't do their work. And if you begin to associate with them and then you realize, wow, this is not the best person for me, then you have to disengage. And it can be uncomfortable to do that if you're living 10 yards from someone. So I think it's best to lay low. And as it happened, like with me, my friendships happened organically with Michael and others, but I didn't force it. And I said, no, I don't want to walk the track with you. No, I don't want to play softball. No, I don't want to play tennis. I just want to do my own thing. And that it enabled me to create a scenario where I avoided problems. Even when Michael was in the penitentiary, as he wrote in Earning Freedom, a book that all of you can get. I believe we give all of you the ebook for free. Michael talked about, despite the volatility in the penitentiary, he found a job that I think was suicide watch from like noon to 6 a.m. He could be alone, he could study, he could avoid the problems, then he'd have more free time during the day. Create a scenario you can defend to your family, but that also helps you avoid problems that can persist. Now we're going to spend the last 15 minutes with Jon going through questions. I'm going to start at the bottom and work my way up. Gary asked, what should be included in a release plan, John, for those in retirement age who plan on retiring and don't need to work?
Yeah. Tell us you plan on retiring and don't need to work. But
That's it.
But also tell us how you're going to spend that time. So what productive activities are you going to be doing? Are you going to be doing volunteer activities in your community? Are you going to be heavily involved in an exercise program? Are you going to be caring for your grandkids that you haven't seen for the last 6 years or whatever the length of your incarceration was? Start outlining that, because otherwise, if all you're going to do is retire and sit on your couch and watch TV and, catch up on the Oprah that you missed while you're incarcerated, there's no need to put you in a halfway house or on home confinement, because there's no productive activity that you're going to be doing while you're in that halfway house on home confinement that's going to benefit you when you release. So be really careful about saying, yeah, I'm going to retire. I'm not going to do anything.
And it probably does. Yeah, and it probably doesn't help your agenda to get off supervised release early if you say you're retired and watching Oprah all day, right? So all these things, right. Okay. Someone said, please explain that in camps you are required to work. I started 12 cents per hour. I left making 79 cents per hour. Presuming you're capable, you're going to work in the minimum in any prison. Isn't that correct, John?
That is correct.
Okay. Rosa commented, my brother-in-law was recently transferred to Lee Camp, and they do not have a case manager, counselor, or facility administrator. How does he get an opportunity to discuss his activities, productivity, and release plan? What would you suggest he do?
Yeah, so again, the Bureau of Prisons is a lot of vacancies. However, they're still tied by policy to doing teams. They're still required to sit down and meet with everybody that comes in. They're required to do that on specific times. If you're not getting those team meetings, so you're not being seen within the first 72 hours of your arrival, you're not being seen, within 6 months thereafter, you really need to start inquiring about why and who can you see. Realizing that the Bureau of Prisons is going to do those reports. They are going to move that forward. They're evaluated on that. They're a critical part of what's going on in the Bureau of Prisons. So they are going to happen. Sometimes you have to be patient. It may not be happening when you think it should be happening, but there are set timelines within policy that you are supposed to meet with your case manager.
Thank you. Someone asked about getting sentenced next week, and is there a chance that you get remanded or self-surrender? It's possible you get remanded. Some judges, like Judge Dimitriolis in Florida, have a policy of remanding every defendant. I would encourage you to ask your lawyer, to ask the prosecutor as a courtesy, is there a chance you're going to take our client in? Some judges have a policy. Some judges, I was at a sentencing a few months ago with Judge Carter in Santa Ana, where he made pretty clear when the sentencing hearing began, he was going to remand the defendant because he asked the marshals to come in. So some judges are going to go back and forth. Again, that comes down to your pretrial supervision, your post-defense conduct. Let's talk about that for another moment, John, before we get to more questions. You get indicted, you plead guilty, the government is always watching. That post-defense conduct is going to influence the sentencing and the potential remanding at sentencing or self-surrender, correct?
Correct.
Okay, so for all of you, there are a lot of people like yours truly who got a longer prison term because of decisions I made after I learned that I was in trouble. I exacerbated my struggles. So part of our goal, or when we ask people, like, what is success for you? They'll say, well, what do you mean by that? What is success for you? I think it's not making matters worse. And a lot of people tend to do that. So I would argue if you've been compliant on pretrial, it's likely that you're going to be able to self-surrender to the federal prison. Our good friend Frank asked, which programs would be the best to participate in during our journey through a minimum security camp? How can I contribute to my early freedom as well as make a contribution to those individuals I'm incarcerated with?
Yeah, so the best program, of course, is RDAP, because you're going to get time off your sentence. Unequivocally, any other program I would recommend to you is based on just my personal knowledge and my personal opinion. Any program that offers you vocational skills. So if you can go through an electrician program, if you can go through a forklift driving program, if you can go through a truck driving program, which some of our facilities have, get on those every single time. If you can get on a waiting list and get into those type of programs, they're absolutely beneficial because they show positive activity and they show work activity that you can document on any resume when you're moving forward for employment. But realize that, again, idleness breeds problems. Be as active in programming as you possibly can, regardless of whether or not you think it'll help you personally. If you get one thing out of that program, and that is that you're not lying in your room on your bed thinking about your personal situation, attend a program. And again, idleness is everybody's worst enemy in prison. The busier you can stay, the better you'll be.
Thank you. Our friend Roxy asked, and we can provide some confirmation on halfway house. Is the maximum amount of time that can be spent in the halfway house or home confinement 18 months or 1 year?
Neither.
Okay, so let's talk about that, because someone writes it online, and because someone's put it on a website, people presume that it's true. As a reminder, just because it's online doesn't mean that it's true. You want to vet and verify, and that's why we have experts like John on to clarify.
So the maximum amount of time you can spend in a halfway house without any application of earned time credits is 12 months. And that's also not taking into accord the elderly offender program, because the elderly offender program allows you to spend additional time on home confinement. Realizing, again, elderly offender program and home confinement without the application of any earned time credits. Home confinement allows for 6 months or 10% of your sentence, whichever is less. And the elderly offender program allows for you to serve 1/3 of your sentence imposed. So if you're given 6 years, you can spend 2 years on home confinement under the elderly offender program if you otherwise qualify. Additionally to that, so if you have, let's say you got your year off your sentence for the first 12 months of your earned time credits, but you have an additional 12 months earned time credits. So you can get that 12 months for earned time credits, and then you can get any additional time that they recommend up to 12 months under the 5-factor review contained in the Second Chance Act. Now, the likelihood of that occurring is pretty small, but you can get that additional time. And there are people that's going to happen, probably not for another 2 or 3 years, but you're going to see 2 or 3 years of earned time credit based on their sentence length. Conceivably could get that 1 year off towards supervised release, and then could get 2 years in a halfway house based on the level of earned time credits that they've received. So the longer your sentence is, the more earned time credits you get, is going to result in more earned time credits that can be applied to your
Jesus. Sorry, please continue, John.
No,
I'm sorry.
I'm done, I think.
Good, thank you. So helpful. We have a few minutes left. Someone commented they still haven't gotten their credits, and I know it's difficult to wait. Matt O'Callahan is on our team. He had a 51-month sentence, leader in RDAP, home in about 17 months. Matt sent a great message a few days ago that said, my update was moved. Matt, can you quickly summarize how much time were you given, and how long did it take for you to receive those credits?
Yeah, no problem. Hey, Justin. So it came in different tranches. The FSA that I received some this time last year. I received some this past January, and then I got my last block of it on Saturday. It's a little incongruous as to when different people receive their time credits. They're supposed to be once a month. There's supposed to be an update. That seems to be still a little wonky. It was my understanding that there was a misclassification in my risk level at one point. And once I got corrected, I received the balance of my days, whatever the question, but I definitely think that the process is getting more streamlined and cleaner and more efficient every day.
Yeah, Matt, I couldn't agree with you more. I think that's exactly what we're seeing. We're seeing some now, especially those that are closer to their release date, where they are getting that every 30-day update. We are seeing some that have longer periods of time to serve that are seeing it after their teams. So every 6-month teams. But I agree with you. I think the process is becoming very, very streamlined now. And I think we're going to see that it's more consistently being updated every month here in the future.
Right.
Thank you, Lisa. I'm going to come to you in a moment. I want to answer a couple of more questions. Someone wrote, I pled guilty to healthcare fraud while I worked as a mental health professional. I have contemplated starting to be a life coach with those impacted by the justice system. Possible or too far-fetched? It's possible because we're doing that right now on this webinar. So absolutely, it's possible. Of course it's possible. And we welcome you joining our community and helping people get through the system in any way. If our team did it, of course you can as well. We wish you we wish you tons of success. With that said, a few minutes left. Lisa, thank you for your question. I've asked you to unmute yourself if you can do that, and then ask your question for Jon.
I'm on home confinement now for about 12 months, and I just wondered if there's any credit earned while I'm not causing trouble.
Well, thank you for not causing trouble initially. So yes, the Bureau of Prisons, what they're doing is prior to your transfer out to halfway house, or for those that are already in the halfway houses, they are applying those credits, and they're applying them at full value. So if you're earning 10 days of credit for every 30 days, they're applying those while you're in the halfway house or on home confinement. And it was applied prior to your transfer to the halfway house or home confinement. Unless you've been there since they applied credits, and then you should see those updates to your sentence computation now.
Okay, thank you.
Very helpful. Oliver, you asked if you can unmute yourself to ask a question. Please ask away.
I just wanted to know, how do you bypass the halfway house and goes to home confinement?
Yeah.
Did you hear that?
Nope, I missed it. How do you bypass halfway house to go to home confinement?
That's correct. She's serving an 8-month sentence, and 5 of them is incarceration and 3 of them is in the halfway house.
Okay, so remember, 8-month sentence, you're only going to get 10% of that on home confinement, absent the earned time credit. So, you're talking about what, 30 days, maybe 24 days, something like that with my quick math. So it really wouldn't be beneficial to you to say, hey, I want to bypass the halfway house and go directly to home confinement, because you're going to stay longer in the prison environment. So you have to be very cognizant of those limitations. 8-month sentence, you could have 80 days roughly, earned time credits. I would definitely take those 80 days in a halfway house if they allow me to.
Okay, thank you.
And to reiterate, if you're ready to go to the halfway house, if you have a job, if you have employment, if not, it's part of the reason so many people wish they were back in federal prison. Just some questions. One, do you update the release plan? As Jon said earlier, it's a dynamic growing document. You update it as you're programming and growing and making progress. Document it and share it. What 10 pages could eventually become 100 pages. To the question, and we have a couple of minutes left here. Jon, I was told good time stops when you leave the facility. Would you confirm or correct that?
Good conduct time is not contingent upon the time that you spend inside a Bureau of Prisons facility. Good conduct time is based on the length of sentence. 54 days off good conduct time for every year of incarceration.
Couple of minutes left, Jon. Let's talk quickly about medical. Some people, if they're not getting medications that they need, would you encourage them to spend time on the formulary, ensure everything's in the probation report? Medical's a big deal within the BOP, and some people are concerned they're not going to get the treatment they need.
Yeah, if you have a medical condition, it's incumbent upon you to, number one, carry your medical records with you when you surrender to the Bureau of Prisons. Number two, it's incumbent upon you to make sure that all of your medical gets very accurately recorded within your PSI. And that is an area that I would tell you that even after sentencing, if your PSR does not accurately reflect your medical, or if there's an update to your medical, get that to the courts and ask the court to please submit that to the Bureau of Prisons. It can affect where you're designated, and it'll affect the quick treatment of medical conditions as soon as you arrive at a medical or at a facility.
2 minutes, couple of minutes left. Last 2 questions I want to address. Jon, there are people we work with a lot of great lawyers, though sometimes lawyers don't understand the BOP. And the reason our team, Scott, Matt, and me say we don't negotiate plea agreements because we're not a lawyer. Yet some lawyers try to dispense and frankly bill or prison advice. And there's someone on this webinar right now whose lawyer said, when you surrender to prison, I'm just going to send a letter to the warden articulating why I think you're worthy of a compassionate release. And my response, well, lawyers aren't involved in that part of it. There is a remedy process you need to go to while in prison. Now, if you're going to court, the lawyer can be involved in that process, but can you articulate the power of self-advocacy after sentencing and what the inmate does relative to a lawyer?
Yeah, if you're going to retain a lawyer to help you in your compassionate complete plea agreement argument to either the Bureau of Prisons or to the courts, regardless of who you're going to make that plea to for compassionate release. If a lawyer is going to document that for you, then bring it with you when you surrender to the Bureau of Prisons. Conversely, yes, the lawyer could send that letter into the warden, but it's not going to have the same impact. It's going to be trickled down, and the warden has the ability then to make a determination on what he's going to do with that letter, to include trashing it.
John, I've never seen it have an impact. I've seen people pay $10,000 for a letter on impressive lawyer letterhead, and it gets shredded and nothing ever happens. I mean, that's maybe you've seen it differently. I've never seen it be impacted. I'm sharing that for someone specifically on this call who's the lawyer essentially said, I got everything covered throughout the whole journey. And I think it dismisses the power of advocacy and in building.
Well, and I will tell you, it very seldom has an impact. I have seen some cases where it does, but those are usually your extreme cases. Self-advocacy for compassionate release, going in there and telling them why you feel you're eligible for compassionate release and why it'd be helpful. Unless you're going to petition the courts, I think it would be rare that you need a lawyer.
Last question, John. I know it's a big subject. Summarize in 1 minute if you can. Someone just said, can you discuss again good time credit? What is the good time credit?
Yeah, so good conduct time credit is time usually up to 54 days a year that you're eligible for if you don't receive disciplinary infractions within the Bureau of Prisons. So 54 days a year would be taken off of your sentence if you have good conduct while inside the prisons.
Got it. With that said, we had a hard stop with John at 11. We're at a couple of minutes past. This is his 4th time. Of course, he can return. Perhaps, John, we may coordinate that for next month or the following month. But we're grateful for your continued contributions. Everyone, here's our commitment. We will get this webinar up on YouTube tomorrow. Every resource that we mentioned in here, whether it's preparing for prison, the importance of a release plan, how to avoid problems in federal prison, the prior interview that John did with Michael Santos, the interview that Michael did with Chris Maloney. Every resource mentioned, when we send out the replay to everyone, we will link to all of them. And so you'll have access to them. That's our commitment. Just give us a day or so to get it out. With that said, we look forward to seeing all of you next Thursday. John, my friend, thank you. Scott, Matt, and everyone, thank you for contributing. And have a wonderful and safe weekend. And last but not least, my friend Ron, getting ready to surrender for 6 years. We're going to do a YouTube video together following our webinar next week, and we're going to share it with the community. John, thank you again for contributing today.
Thank you for having me.
Thanks, guys. Bye-bye.